Well, joining me to discuss more on the state of emergency on Rivers State now is GT Ogunye, who is, of course, a legal practitioner. Thank you very much for joining us on the program. This whole emergency thing generating a lot of controversy, especially as to whether this emergency should have been pronounced, and especially whether the president actually has the right to have suspended the democratically elected government of Rivers State. I'm talking about the governor, the deputy governor, and of course the members of the State House of Assembly. From your understanding and reading of the law, what exactly is your take on it?
Now, thanks for inviting me. The state of emergency declaration, of course, was like an accident waiting to happen. Following the recalcitrance of the parties to the conflict, the political conflict in Rivers State, it was predictable that at some point, when the parties will get very close to the precipice, something like a deus ex machina will happen. And so when that was pronounced yesterday night, I was very sad, indeed distressed, because democracy, particularly constitutional democracy, is about a representative government.
Yeah.
So if the representative of the people are therefore suspended or removed from office within the term or within the tenure that they've gotten from the electorate, there is a disruption, a subversion of that process in a way, and so the people will not have a fulsome service from those that they've elected into office. So it was not something that was very good. Now, I know that a lot of controversy has trailed the aspect of the declaration of a state of emergency, bordering on the suspension of the governor and the members of the House of Assembly from office. The question that has been posed is whether the president, acting under Section 305 of the Constitution, has any power to suspend a governor as is done at all, or before the National Assembly will affirm the terms of that proclamation. Now, the president informed the country yesterday that following the proclamation, which has been gazetted in the Federal Government Gazette, same has been transmitted to the leadership of the National Assembly so that they could then exercise their constitutional right to vote on the proclamation, to reject it or to accept it and approve of the proclamation. In the meantime, the president also informed Nigeria that he has appointed a retired vice admiral of the Navy to head the Rivers State government as a sole administrator. And there are a number of other details which the president also enumerated, which will be handed over to the National Assembly for consideration while they are voting. Now, it's been submitted and pungently argued that there is nothing under Section 305 of the Constitution that permits the president from the central government, or what we call the federal government now, under a federation, to dissolve a subnational government, as the president has purported to do with the suspension of the legislature in Rivers State and his governor from office. And furthermore, people have also stated that under the Constitution, there are 4 ways in which a governor duly elected into office can get out of office: by death, resignation, incapacity under Section 89 of the Constitution, or by removal from office, which otherwise is called impeachment. And that both the governor and the House of Assembly owe their common existence to the Constitution under Section 90 and Section 176 of the Constitution. And that, therefore, the president that also owes his own existence in power to the same Constitution in the executive branch of government, just like the National Assembly also owes life to the Constitution, cannot from the center dissolve the government of a state. That argument has been made. My view is that under the Constitution, declaration of a state of emergency does not necessarily denote or connote that democratic structures in the state be dissolved. No. It is not so stated in the Constitution. The Constitution has laid out the procedure for a declaration of emergency. The Constitution has also given the legislature to define the parameters of the emergency power to be exercised and legislate on it and come out with it. But the Constitution has not necessarily stated that once there's a political crisis in a state, that perforce will mean that if there's the declaration of a state of emergency, the governor should be removed from office or suspended from office while, the system will want to find ways to resolve that crisis. And in a way, at an intellectual level, and I'm talking about, legal reasoning, it is reductionist to so think, because declaration of a state of emergency is not necessarily in respect of political conflict. There could be a major disaster, there could be a landslide, there could be a pandemic, there could be a medical emergency, there could be, so which will not implicate the office of the governor or the
but in this case it's more about
member
politics.
of the House of Assembly. Yes, more about politics. That's correct. And so, in that case, indeed, a state of emergency may be declared in a state to bolster the democratic structures in the state, so that they will not only exist, but they will become stronger. And we saw this happen in 2013 under Goodluck Jonathan. Nigerians can recall that he declared a state of emergency in those states in the northeast as a counter-terrorism and counter-insurgency measure to enable the military to be better able to do their jobs. And I can recall, and Nigerians may not recall this easily now, that on that occasion, a number of pundits condemned President Goodluck Jonathan for declaring a lifeless state of emergency. That what kind of a state of emergency will not, warrant the removal of those governors. Some even suggested that those governors were complicit in what was going on and that they should be removed from power. But, it was clear that why that state of emergency was declared was to preserve democratic governance. The insurgents and the terrorists haven't declared that they didn't want education and they didn't want civil governance. So it will have been counterproductive to then put forward a state of emergency declaration that would then undercut and undermine that civil government. So I'm just saying this
but would you say that situation, sorry to interject, but would you say that situation in 2013, would you say that situation is the same? Because the circumstances are different somehow.
No. That's the point. I am just trying to broaden and deepen the argument now and the discussion. Now, for those who may argue that in all situations, declaration of a state of emergency does not warrant the removal or suspension of a governor from office or member of the House of Assembly from power, if their continuity in office is indeed the propeller of the crisis that had put the state in a state of emergency, what will be done in those circumstances?
Yeah.
Before I even deal with the historical perspective here in Nigeria. So what will happen? If, for example, a governor of a state follow a resolution of the House of Assembly of a state, seceding from the country, is now implementing the decision of a House of Assembly that seceded from the country. Of course, nobody will suggesting that a president should not put in measures to remove, not only remove those persons from power, but to arrest them and try them for treason. Okay, so the argument is not broad enough the way people are jumping into it. Now, for guidance, and this is very important. Historically in Nigeria, a declaration of a state of emergency like this one had always carried with it the suspension of those who are in power from office. In 1962, during the Western Nigeria regional crisis, Chief Samuel Adoke Akintola was removed from office. Chief Maje Kodumi was made the administrator of Western region. On that occasion, the governor, perhaps because of his royal prestige and esteem, had to resign and move out of the governor's lodge. And I'm talking about Sir Adesoji Aderemi, the Ooni of Ife of that time, and later Chief Adams was made the administrator of Western region. And after that declaration, there was a debate on the floor of the National Assembly whether a state of emergency, existed in the West. Of course, the leader of opposition, Shobafemi Awolowo, said no, it didn't exist. The people on NPC, NCC side said it existed, and that declaration was sustained. Interestingly and instructively, although constitutional experts may say that those decisions were not rightly decided now, when that happened, there were cases that were instituted in court. Williams and Maje Kodumi, Adengbero and Akintola, Adengbero and Balewa, all those cases. And randomly, the suspension of the Premier and the Western House of Assembly, for that 6-month period was sustained by the courts. Now, later on, after 1999, we've had the situation in Plateau State.
Yes.
We had this under Dariye. We had the situation in Ekiti State under Fayose. And in both cases, sole administrators were appointed following the removal of democratic structures, following the suspension of democratic structures, namely the House of Assembly and the governor. In Plateau State, Brigadier General M.C. Ali, now late, was the sole administrator in Ekiti State. Major General Tunji Oluri, also now late, was the administrator. And of course, there were arguments then, as we have now, that the removal was not contemplated by the Constitution, the suspension was not part of our democratic structure. It was Obasanjo that was doing that because he was a military man. So this is dictatorial, this is dictatorship and all that. And that in a federation, a central government cannot dissolve a subnational government, etc., etc., etc. On that occasion in particular, the Emergency Power Act of 1961 that the president claimed it relied upon to do all that he did when the argument was raging, was demonstrated quickly to have been spent, because in the 1990 Law of the Federation compilation, that law was omitted. It was spent. So that law was no longer alive as at the time, the President Olusegun Obasanjo and his government claimed that they were exercising that Emergency Power Act. However, when opportunity came, and this is the solemn point I think that we should make, when crises like this emerge, when an opportunity came for the Supreme Court to determine whether the suspension of a governor or House of Assembly were necessary concomitant aspects of a declaration of state of emergency, and whether they were legal or constitutional, the Supreme Court, didn't take that matter. How did it resolve it? The matter came in the case of Plateau State government, the House of Assembly of Plateau State versus Attorney General of the Federation. I think it's in the case reported in 2006, 3 Nigerian Weekly Law Report, passed 967 at page 346. So here was a case that was instituted, and the sole administrator came to court, deposed to an affidavit. He said, I'm the representation of the government of Plateau State at this time. I didn't authorize any case to be filed. So they asked the member of the House of Assembly and the Attorney General that came to Supreme Court in the name of Plateau State, who authorized you? They said yes, nobody authorized them. That after the expiration of the state of emergency, they tried to do a retroactive, authorization. The court said no. What was important is that at the time this matter happened, you are not in government any longer. You are no longer in the house. You've been suspended. Therefore, you lack the local standing and the legal wicket to even institute the action. So on a preliminary point, the case was sent out of court. The case was struck out. So the substantive issue of whether, the constitutionality of removal or suspension of a governor, all those issues weren't decided at that time. And believe you me, that doyen of constitutional law in Nigeria, Professor Ben Wabweze, was representing Plateau State government then. All of them were in court, but that's how the Supreme Court decided the matter. Meaning that, and those who were in the team, Nikitobi, Kutigi, all of them were there. So they were not, that court was not less cerebral than the court that we have now. So the court didn't take the matter. Meaning that as at today, in spite of the pontification that is now rife in the polity about the legality or constitutionality of what this president has done, including what the NBA had written, in giving its own position, the Supreme Court had not, in any of these instances that decided, taken the position that suspension from office is illegal and unconstitutional. So what are we left with? We are then left with my own opinion, your own opinion, the opinion of the vociferous commentariat, and so we are not going to. So that if Ubara, based on that precedent, if Ubara and the House of Assembly were to approach the court now and say, look, there is an issue between us, Rivers State, and the federal government, Supreme Court, the Supreme Court will say, which Rivers State? You are no longer, because the fact is that you have been removed or suspended. That's if the National Assembly, affirms and approves of the
Let me ask you, I get this point. Okay. There's a question I want to ask you. Yes. So, you're quite right. Section 305 does not in any way spell out, does not say that a governor can be suspended in an emergency or the State House of Assembly. But when it says the president assumes extraordinary powers, what does that mean? And besides, the Constitution, that part of the Constitution too, did not even define what an emergency is. Yes, as it does not define the very details of an emergency.
Exactly. Extraordinary measure is an unusual measure. It's just that, these occurrences are happening in the political space. And those who are taking decisions are politicians who are also accused of partisanship. Otherwise, there can be measures that are extraordinary that can be taken to justify the kind of thing that has been done. However, lately, and I've just seen that, I will still need to confirm that, in 2018, there was the passage of a bill. I don't know the status of that bill now, whether it's formed part of our laws, called the Emergency Powers Act. The Emergency Power Act repealed that emergency power formally repealed that Emergency Power Act of 1961 that I said had been spent because it was not reproduced in the Law of Federation of Nigeria 1990 when it was being compiled. So that new act formally repealed it and reenacted a new Emergency Power Act. Interestingly, under that Emergency Power Act, passed by the National Assembly in 2018, there is a section 11, 2, that empowers the president to suspend a governor or a local government chairman or anybody in that state as part of the emergency measures. I've said that I will need to confirm later today, if that law is really, really codified. But anybody can do a Google search, you can do your basic research. The Senate passed that bill into law. And so if that law exists, and so many laws are out there that lawyers may not even be very familiar, truth be told, except occasion arises and you then do your research. If that law does exist, it would then mean that what the president has done is even covered by a statute or legislation unknown to many, except the law does not exist. But if the law does not exist, it would then mean that this president has done what the former president before him have been doing, which no court of law had declared categorically was unconstitutional and illegal. So what we are left with, as I've said earlier, is opinion, enlightened opinion, that in a democracy, in a federation, one tier of government at the national level ought not to exercise that power to dissolve a subnational government that is not right, and so on and so forth. But, going forward, I think that what has happened in Rivers State is full of lessons to many people and Nigerians. Contrary to the way people have been belittling the gravity of this offense, because I regard it as an offense. How can a governor in sneakers and trousers openly supervise the destruction of the House of Assembly? So that state of emergency being declared now could have been declared then. For me, it was a mortal sin that the first arm of government in a state was being physically obliterated. And in addition, that governor then said, I have decided, based on your defection and based on my recourse to self-help, that I won't recognize you anymore. So I will only recognize 3 legislators. And the matter went on, and lawyers were arguing, and they were collecting briefs. They were arguing it. 3 can be better. Yet they are defected. Whereas under Section 109 under the relevant provision 109, we talked about defection. The provision, subsection 2, there says that the Speaker shall give effect to that defection and then the vacation of seats. In this case, the Speaker was part of those who defected. What do you then do? The little law that I know says that in that occasion, or on that occasion, any aggrieved party may then approach the court to seek an order of mandamus. I've said this before, to compel the Speaker to perform his constitutional duty, to declare himself and the other defectors. But that was not the part of the rule of law. The part that was taken was self-help. I have my own house now. I will present my budget before that house. And when people were saying, go and represent the budget, there were pundits in town saying that there is no provision in the Constitution that allows the representation of a budget. And so there was no provision in the Constitution that allowed the reproclamation of a House of Assembly. So in Edo State, Obaseki committed blue murder by proclaiming certain persons and refusing to proclaim others. So that in the life of that legislature, that session, that assembly in Edo State, the members that were excluded, about 12 of them were not allowed to sit at all for 4 years in this country. And I have argued that this argument that we go about making every day as it's unconstitutional, is whatever, they have defected, they just a recipe for nonsensical crisis. Because I know that even in the United States, for example, when Obama was being sworn in, Rehnquist, and you can get the tape, anybody can get the tape, the Chief Justice of the United States missed out some lines before a global audience. You know what happened? The following morning, having recognized that, Rehnquist came back to the White House to have Obama resworn properly, to regularize his taking the oath of office. That's what happened. So when people are saying that there could be no representation of the budget, it is not done anywhere, the governor must be strong. I said, what are you talking about? These people were in the same political party. So why are you dabbling in there? Let them be at peace so that people of Rivers can have good governance. That's what was important. But that admonition was taken as, trumpeting the wishes of somebody
let me ask
in Abuja, which
let
is
me
not
ask you this,
the case anyway. So
let me ask you this question, sir.
It's full of lessons.
Yes. Yes. We've seen governors suspend local government chairmen in this country, and they still do it. I mean, they suspend local government chairmen. We saw it even in Edo. The governor suspended, across states. We've seen local government chairmen suspend. We've seen governors suspend local government chairmen. So I'm just wondering if governors can suspend local government chairmen, of course, not just suspension. It's, of course, it has to be based on certain reasons, of course. So why would it be abnormal, for instance, for the president, after declaring a state of emergency, to suspend a governor or a state house of assembly, especially when, the governor and the state house of assembly are actually the very reason for the state of emergency?
No, let me quickly react this way. The suspension of local government chairmen and dissolution of the councils, at will by governors is an aberration. And I think that the courts, including the Supreme Court, have ruled on that, which has led us to the stage of now saying that their money should be paid to them directly. And all that. Because if you look at Section 7 of the Constitution, the state legislature is charged with the responsibility of putting in a law that will guarantee the democratic governance of local governments. And so, if under any guise or disguise, a governor under that law or a House of Assembly under that law is taking the power to arbitrarily dissolve and disband when there is no state of emergency in the local government and all that, that must be taken as an aberration, which our courts have frowned at and which they've said should not happen anymore. So that the era of caretaker local government, where some governor will even come to power and for 4 years, they will not have local government chairmen and use that as an opportunity to be directly administering money meant for local government, stealing those monies and so on and so forth. We won't have that kind of anomaly any longer. Now, the issue in comparison here, is that under the Constitution, under emergency power situation, you have situation in which the governance are broken down. In the 1962, what happened? Chief Obama argued and argued and argued without succeeding that there was no state of emergency in Western region. That it was only in the legislative chambers that you had a fracas when they wanted to take a vote to vote out Chief Samuel Adoka Akintola. Because under the Constitution of Western region, the governor had taken the provision of Section 33 that says that if it appears to him that the premier no longer enjoyed the confidence of a majority, that the premier shall be asked to resign. And signatures have been collected And the members had shown overwhelmingly that they no longer support Chief, they no longer supported Chief SL Akintola. But Chief Samuel Adoge Akintola was now insisting that that vote must be taken on the floor of the House. That vote must be taken on the floor of the House. When the vote was taken, crisis ensued. They jumped on the table, they broke the mace and all that. Balewa's government seized on that to say, oh, there's a state of emergency in the West. And that was how a state of emergency was declared, in the West. So, and then leading to the removal of whatever. Yes, state of emergency declaration has not been easy. It's been political, it's been legal, it's been constitutional, it's been many things. But I'm saying that on this occasion, what happened in Rivers State shouldn't have degenerated to this level. And finally, I will urge that the president should go back to the accord that he encouraged between the parties, which they signed, which they later resiled from. Because you see, a mere declaration of a state of emergency
does not solve.
Recalcitrant combatants, political combatants, will not assuage them. They will only wait for them to resume fighting when the expiration is over, or when the expiration of the state of emergency arrives. So what is needed is that during this interregnum, during this period, there should be some fence mending, some give and takes, some working together and all that, so that they can then use the remainder of their tenure in peace. And the people of Rivers State will also live in peace and won't have all these crises that we're having now, in Rivers State. All
right. Just before I let you guys, I just wanted to take a listen to the Attorney General of the Federation. He's actually spoken on it. I want us to take a listen to him, and then I want to get your reaction. Let's take a listen to what he said.
The president came out boldly yesterday to say the situation cannot be allowed to continue. A situation in which the critical economic life of the nation, what is giving lifeline to the nation, to be, criminally touched without any response from those who would ordinarily be expected to do so, cannot continue. But don't forget, the whole thing started or crystallized with the judgment of the Supreme Court that was handed down on the 28th day of February 2025, in which the Supreme Court, that's the highest court in the land, made a categorical pronouncement after making very pronounced findings, profound findings of breaches of the Constitution by the parties involved, particularly the governor of Rivers State, came to the conclusion that he was acting like a despot, and that as the situation is in Rivers State, there is no government. These are very serious and very weighty allegations that only an irresponsible head of state or leader will fold its arm to and ignore. Like I said, he took a very bold decision. We were all there when he made a public announcement, addressed the public, in which he chronicled all the facts from Genesis to Revelation. So I'm here. If there is any question to be asked on that, then I will be able to respond. But before then, don't forget that the judgment of the Supreme Court had been widely reported and published in the papers. So the president was not a party to it. So a question of trying to influence anything would not arise. And by virtue of certain provisions of the Constitution, everybody has a duty to ensure that judgment of the court is obeyed, particularly coming from the highest court in the land. There's no other person to appeal to. There's no other body to appeal to. It's not subject to any further test of validity. As things are, we all have a duty, collectively and individually, to ensure that we give maximum respect and obedience to the judgment of the Supreme Court. There are occasions when, especially when it comes to national issues, we have to come out plainly and sincerely. Where do you put the Minister of FCT in this case? Was he the one who asked for the demolition of the House of Assembly? Was he the one who said the governor should not present his budget to the House of Assembly? Was he the one who advised the governor not to go through the House of Assembly for purposes of ratifying the commissioner nominees? I don't know, because if you want to look at a case, you look at the facts that have been presented. The Supreme Court made these critical findings. FCT minister did not feature. Whatever the situation, assuming he featured, he would have featured maybe on the side of the legislator. Yes, the legislators. But what we have here is let everybody go home for the first 6 months. So I don't see his hands here in what we have. That judgment of Supreme Court, I will encourage us to read that judgment. There were about 11 of 12 findings against the governor. What sentiment are we bringing to bear, on this matter? I don't think there is any sentiment. What remains is, if the National Assembly feels that the president has not done well, then you won't have the 2/3 majority required to validate his action.
Yeah, Mr. GT, you heard the Attorney General there. Just very quickly, what's your take on some of the things he said?
Given the economic reasons that warranted the declaration of a state of emergency, I wish he had not dabbled in that area. He should have stuck to his forte, which is being the legal advisor of the federal government and the chief law officer of the federation. So in the latter part of his presentation, of course, he did justice to the issue. The conduct of the governor or misconduct of the governor, and he isolated and itemized 3. Demolition of the House of Assembly, no presentation of the budget, and non-submission of the list of commissioner for clearing. These which are fundamental procedures in forming a government and running a government. And he said that the Supreme Court, in that judgment, made almost 25 specific findings against the governor, and that the president has acted rightly.
Right.
Now, he didn't talk about the issue of whether it is legal or constitutional to suspend.
It's not the entire video we played anyway.
Talked about. Yes, from the clip we've heard. So he didn't talk about that one. And I think that's the aspect that is very hot in the politics now, at least today. The people who say, yes, a declaration of a state of emergency is the president can declare it if this occasion warrants and if the 2/3 majority of the vote of the National Assembly approves. After all, the president is the one in control of the security agencies, namely the military, the police, the SSS, the blue-shirted, civil defense corps, and so on and so forth. So he is the one to ensure that law and order ultimately doesn't break down, because there is agents, there is no state police and all that. So you can declare a state of emergency, take extraordinary measures, but don't remove the governor or suspend the governor. Don't suspend the legislature. That's the area of divergence, in the politics. Even for some people who suggested that a state of emergency, is warranted. Overall, as I've articulated here in this interview, I'm not aware of any pronouncement of court, any decision that struck down the suspension of a governor as part and parcel of the declaration of a state of emergency. And so we look up to the court. It will be good, in the future for the court to be able to pronounce on it. Maybe the parties will have to be different, the parties that will approach the court. And those parties will not be robbed of their local standing or their authorization to institute that action. And maybe with that issue of local standing taken care of, the Supreme Court can now directly pronounce on the legality and constitutionality. Until then, as I've said, it is what people think differently that is legal and constitutional in the circumstances that will prevail in the polity as an argument and counter-argument on the subject.
All right. Thank you very much, Mr. GT Ogunye. Thanks so very much for coming on the show, and thanks for your elucidation. Thanks a lot. All right. We'll take a short break and we'll be right back. Stay with us. Don't go away.
Opinions are free, facts are sacred, but truth is universal.
How, in practical terms, can we, for instance, de-escalate the tension?
When you go into public office, you must be ready to answer to the people.
We know where the enemy is. 3 places. The Lake Chad Basin, the border area between Nigeria and Cameroon, and then the Sambisa Forest.
On Digi 360, we give you a complete dose of everything. Opinion, facts, and undiluted truth.
I hardly believe what politicians say in this part of the world.
A new Nigeria is possible, a future is possible.
We delve into the issues, dissect it so that you can understand it, and use it to take action.
I don't think there's any need for any governor to look for grant for ranching.
Digi 360, dissecting the issues.